Greetings everyone, my name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com. I am a copyright and plagiarism expert with 18 years experience in the field. However, I am not a lawyer. Nothing in this video is legal advice, and you shouldn't be getting legal advice on YouTube anyways. However, if you do think a plagiarism expert might be useful to you, whether you need a plagiarism analysis, an expert witness for a legal case, or just a DMCA takedown or DMCA agent enforcement, check out my website at copybyte.com, COPYBYTE.com. That is my consulting site where you can learn about all the various services that I provide. Okay, this week we're going to talk about a very recent but still very important tool that is useful for resolving copyright disputes, at least those within the United States, and that is the Copyright Claims Board, the CCB, or if you prefer to think about it as the Copyright Small Claims Court, you can do that as well, though we're going to get to some of the differences in just a little bit. Now, the CCB is, as I said, less than 2 years old, but has already become one of the most powerful and most useful tools for resolving copyright disputes, especially those that aren't worth taking to a full federal court. So if something goes beyond what you would see for a DMCA takedown, for example, but doesn't quite warrant a full lawsuit, that is where the CCB fits in. So what we're going to do today is we're going to talk about why the CCB was determined to be necessary, what the CCB is, and several things that you're going to want to look out for if you decide to file a case with the CCB down the road. So on that note, we're going to begin with a little bit of a history lesson in terms of why the CCB was deemed necessary and why it was made part of the CASE Act of 2020. Now, the Copyright Claims Board was created as part of the CASE Act of 2020. If you don't remember that happening or you missed the news when it took place, that's okay. There was a lot of things going on in 2020 that I would dare say were more important than the creation of a small claims court for copyright cases. You can be easily forgiven of that. Now, the CCB opened its doors formally in June 2022. We are starting to get rapidly close to the 2-year anniversary of it opening. However, there's a question we've got to address first, and that is, why is there a copyright small claims court, or rather board in this case? Why did people feel that was necessary? After all, there's no similar board for trademark or patent or other areas of IP per se, so why was copyright deemed as being special and needing of this type of board? Well, the main reason comes down to one simple fact, and that is, if you want to file a copyright infringement lawsuit in these United States, you have to do it through the federal court system. And we are not talking to you pre-1972 sound recordings. Shoo, you're just going to complicate things needlessly. Nobody likes you. Go away. Go away. Maybe another video. No, not opening that Pandora's box. It's not really important in the year of our Lord 2024 anyway. But seriously, they just mess things up here. So yeah, if you want to file a copyright infringement claim in the United States, it has to be done in a federal courtroom. And while that's not necessarily a bad thing on its own, federal courts are expensive, they are slow, and, well, to repeat, they are very expensive. Just to give you an example here, and please know that we're going to explain why in a minute, but some of these numbers have to be taken with a bit of a grain of salt. In 2012, the Beastie Boys filed a lawsuit against Monster Energy Drink over the use of samples from 4 of their songs in a promotion for an extreme sporting event. Now, Monster Energy never denied the infringement. The only real issue before the court was the amount of how much they should pay and how much responsibility they bore for that infringement. So this was a very streamlined case, and it actually was resolved by a jury in 2 years, which is an impressively short amount of time. And the Beastie Boys won. They won quite handily. They won a $1.7 million damages award. Huzzah! That's hitting the copyright lottery. They not only got a huge judgment, but it's a judgment from a defendant that definitely has the ability to pay it. That check is getting written. But then this happened. That's right. According to the Beastie Boys, $1.7 million was not enough for them to even break even on this case. Now, this is where we have to take with a grain of salt, per se. The reason here is because $2.4 million, while definitely possible, still seems a little high even to me in this case, and the judge felt so as well, eventually awarding roughly $670,000 in attorney's fees, which the judge said was still higher than an ordinary amount. But even if the judge's ordinary amount is our total arbiter here, it still is well north of $100,000 that should have been spent. So Yeah, this whole thing with attorney's fees, it's not uncommon for the side seeking attorney's fees to ask for an inflated amount, the judge to put the stamp down on it. The fact of the matter is the judge ruled that realistically it did cost them $600,000 plus to bring this case to bear, and even if they had used a cheaper law firm, even if they'd done things in a much more cheap way, it still would have cost well over $100,000. Yeah, that's all well and good if you're looking at getting and collecting $1.7 million in a judgment, but what if the infringement you're seeking damages on is only worth a few thousand or a few $100s? You're pretty much shut out of the legal process. There's no way you're going to go to a lawyer and hand over probably a 5-figure plus detainer to start a case when realistically you might only collect a few hundred to a few $1,000s. It doesn't make financial sense. And this is a problem for both sides of the coin too. If you get sued for copyright infringement, you're looking at the same level of fees. And in fact, if a lawyer is confident that they can win attorney's fees, they may either charge you less or just wait and get their money on the back end out of the judgment. If you're being sued, on the other hand, they're going to want their money up front. So yeah, it can be tens of thousands of dollars to defend against one of these cases, the same as it is tens of thousands of dollars to prosecute them. As a result, these cases are incredibly expensive, and any one where either the damage is likely to be awarded or the damage is likely to be collected don't amount to that just become unfeasible to file a case about. And that is where the CCB comes in. They want to provide a place where claimants and respondents, as we'll get into in a minute, can hash out these things in a much less expensive, much more expedient environment and deal with these cases that are ending in 3 to very low 5 figures, so to speak. It's a tool for handling infringements that would never be practical in a federal court. And once again, that includes both sides, helping both the accused and the people who were allegedly infringed. So to that end, what is the Copyright Claims Board? Excellent question. We're going to jump in. So what is the Copyright Claims Board? Well, one of the first things to note is that it is not a physical place. Any interaction you have with the board is going to be digital, whether that's Zoom meetings, electronic filings, emails, etc. You never really have to be at a physical place. There's no travel involved here, which is a good thing because that's one of the many ways the CCB keeps costs down. And that is fundamentally the goal. The CCB is meant to be a way to address these copyright infringement issue cases without going through all the expense of a federal lawsuit. There's no need for a lawyer. It's meant to be approachable by lay people. That said, if you want a lawyer to represent you, you absolutely can. You can also get help from a law student or a pro bono legal clinic as well. More on that in a minute. But basically, it's meant to be approachable by lay people. So you, as a lay person, can definitely file your claim with the CCB and have it heard and have the whole thing adjudicated without ever seeking the assistance of a lawyer. It's a pretty cool system. Now, that said, there are 2 key limitations to be aware of. First, this is a small claims board. The claims are severely limited in the amount of damages that you can collect. In a normal federal copyright case, statutory damages per work goes up to $150,000. At the CCB, you knock off an order of magnitude of that. It goes down to $15,000. Now, it can be $30,000 per case or per claim, but that would be across 2 works, 2 or more works to be. So yeah, $15,000 per work or $30,000 per claim. That is your cap on damages. The second limitation to be aware of is that this is fully optional. Both parties have to agree to participate. So if you were to, say, file a claim of copyright infringement with the CCB, you would file it, pay a $40 filing fee, and then once the CCB verifies that the claim meets their requirements, they would have you serve papers to the respondent, and the respondent then has a period of time where they can just opt out of the case. They can file an opt-out notice, and if they do, the case ends right then and there. You can refile it in federal court, but you're basically back to square one. You have to go to federal court if you want to address this matter at all. If the respondent is served and then chooses not to respond, the case will continue and you can win what is known as a default determination, and that default determination can include damages, but then you would have to go to a federal court to get those damages enforced. That said, going to a court to enforce damages is way easier than going to a court to handle the entirety of a copyright infringement case. So it still sucks, but it's not nearly as bad. Now, one thing to note about the CCB is that it has pretty much all the trappings of a court, but it's not a court. It goes really far out of its way to make it clear that it's not a court. For example, it's not the Copyright Claims Court, the CCC, it's the CCB. It's a board. So Matters come before the board, not the court, for example. Also, you don't have plaintiffs and defendants. You have claimants and respondents. You also, for example, don't have judgments. You have determinations. They do this thing where they substitute legal words for new ones, but yet at the same time, they still use some legal terms, like I mentioned default determination earlier. Default is a legal term. It's used at the CCB as well. So just bear in mind that even though it operates very similarly to a court, the terminology is going to be different. This can be especially tricky to a lawyer or law student who is not particularly ready for this translation layer, if you will. But basically, the way it works is simple. If you are filing the case, would file the claim. The CCB would determine whether or not that claim is valid or not. If it is valid, they would kick it back to you with a service packet telling you need to serve the respondent the paperwork. You have, I believe, 90 days to do that. Once you do that, then the clock starts ticking. They have a period of time in which they can opt out of the case, and if they do, like I said, the case ends. But if they choose to participate, or if they don't opt out, then you pay another filing fee, a $60 filing fee, and the case moves into what is known as the active phase. And this is where both sides would present evidence. This is where testimony would be heard, meetings would be had, and basically the board would be gathering the information it can. Now, this process is extremely informal. For example, there's very limited use of expert witnesses before the CCB, so someone like myself wouldn't be of much use to you if you're taking a case before there. There's also limitations on how much evidence can be provided, how it must be provided, how onerous this investigation can be, etc., etc., etc. And the end result of it is, after the whole thing's gone through, barring a settlement, which is still probably the most common outcome of cases where both sides are participating, the board will hand down a determination and will rule on what type of copyright infringement did or did not occur and what reasonable damages are. And that's the end of it. Those determinations are enforceable by a court, so if you do get a victory and they choose not to pay or whatever, that you can go through the regular process of enforcing that judgment. And also there is an appeals process to the Register of Copyright, but that hasn't happened yet, so I don't want to talk too much about it just because we haven't actually seen it in action yet. But regardless, that's the entire idea. And the great thing about it is that CCB cases typically take right around 1 year if they go through the full process. That's much less than the 2, 3, 4, 5, 6, 7, any number of years a traditional court case can take. So yeah, if you've got a case where you think the damages are limited, i.e. either the damages you could reasonably collect or the damages that can be awarded, CCB is a powerful tool. The only other point to remember is that it can only be used to target respondents who are United States residents. I misspoke in a previous video, I said citizens. It's United States residents. There is a difference. I appreciate the correction on that. It was a misspeak. But yes, you can only use it on United States residents. You have to provide a U.S. address, and that includes if you're targeting a company in the United States, because you can also, in addition to filing claims against individuals, you can file claims against companies and corporations and other organizations as well. And the final limitation to be aware of is that the CCB cannot offer injunctive relief. Basically, they can't compel a respondent to stop an infringement. Though if the infringement continues after a CCB judgment, obviously you would have a pretty strong case if you took that to a federal court. But yeah, basically speaking, there's no injunctive relief, United States residents only, claims limited to $15,000 per work, $30,000 per claim, and it's opt-in. Parties have to agree to participate either by tacitly permitting to, meaning they get the service and they do nothing, or by actively agreeing and participating in the case. That's the CCB in a nutshell. And to that end, I'm imagining that there are some of you out there that are thinking, wow, this does sound like a very popular tool that I should check out. But before you do, there's a few things I want to make sure that you're aware of. So what do you need to know before you file a claim with the CCB? Well, there are 3 things I definitely think you should be aware of before you start looking into the possibility. First is that if you're going to do this yourself as a layperson, you're going to need to spend some time. A fairly significant amount of time going through all the documentation that the CCB provides. And for the record, their documentation is excellent. They have a handbook to the CCB itself. You're going to want to read that. They have several primers on copyright law. Definitely going to want to read that. And basically, go through some of the other cases in the CCB. The entire CCB case history, including all the filings that aren't marked as private, are available for perusal on the CCB website. Just go through the case search feature and have a look around. Pay special attention to any final determinations the CCB has issued, because those are the decisions, the quote-unquote judgments of the board, if you will. So yeah, pay special attention to those. Now, you have an alternative. If you don't want to spend that much time, you can get a lawyer to represent you, but that's obviously going to raise your costs in this. And it may raise your cost well past what you can hope to claim through the CCB, because remember, damages are going to be limited and there are no attorney's fees awards at the CCB. So every dime you pay that attorney is a dime you're not guaranteed to get back. You do have a third option, which is you can use one of the pro bono legal clinics that the CCB lists on their site. They have several in a variety of regions all over the country, or you can get the help of a law student, which means you can just go down to your university, give them a call, shoot them an email, see if there's a law student willing to help you get through this, and give them some practice in the legal field along the way. So that could be a win-win situation. But yeah, basically you need either a lawyer, a law student, or yourself to represent you, and one of those options can get quite pricey. One of those options is going to take a great deal of time, and the third option is just simply not guaranteed. Be prepared for one of those three eventualities. The second thing you need to note is that the $100 total filing fee with the CCB, that's $40 for the initial claim, and then $60 for when the case moves into the active phase. And for the record, I'm completely and deliberately ignoring the smaller claims proceeding, which does reduce the filing fee costs and also streamlines the case even further, but also further reduces damages. That's not relevant to this conversation right now. Most people seem to just take the regular CCB process. But regardless, that $100 filing fee is not going to be your only cost. There are two other costs that you need to consider. The first is you are going to have to register the work with the U.S. Copyright Office. Now, you don't have to have your registration certificate in hand when you file the claim, but you do need to have sent it off. So that's going to be a minimum of $45, more likely $65. Most copyright registrations cost $65. Either way, if you haven't already registered the work, you're going to want to factor in the cost of a copyright registration as part of the cost you're going to incur, even if you represent yourself in the case. The second, and the one that seems to trip the most people up, is that whenever the CCB looks at your claim and goes, yep, good job, you're going to be required to provide process service to the respondent or respondents. Now, that amount differs wildly from place to place. But when I did an article on the actual cost of the CCB, link in the description, I found that about $100 per respondent was the normal. So if you file a claim with the CCB, and you have two respondents in it, then you're going to have your $100 in filing fees, $200 in process service fees, and if you haven't registered the work previously, you're looking at $45, $65, or more in copyright registration fees. So just be aware that those costs are there. Now, to be clear, that's still way, way, way cheaper than a federal case, even if you represented yourself, which would be absolutely foolhardy. The federal court is not designed to be used by lay people. This system is. There's a huge difference there. But regardless, you need to be aware of those and make sure you take that into account when deciding whether or not the CCB is worthwhile and whether or not you can afford to go through the process. $300, $400 may not be a lot of money to some people, but to others it is a great deal of money. So please be aware of that. The final thing that you need to be aware of is that if you're taking a case to the CCB, you're going to want to be able to prove some kind of actual damages. Now, this is true in a regular copyright case too, but it actually seems to matter even more with the CCB. This has been a big issue for photographers. Now, much of the CCB has been photographers filing claims against companies, websites, and other entities that use their images without permission. A pretty good use, as these cases often would never generate enough damages to justify a federal court case, but may be able to be resolved through the CCB. However, the CCB's made it very clear that the way they're going to calculate damages is at a basis of what you can prove your actual damages are. And to be clear, that's not uncommon in the federal system either, but the CCB is being very rigid about this. Basically, whatever damages you can prove, you either lost or they gained. So think about it as a licensing fee that was unpaid or an amount of money they earned from it, the CCB is probably going to give you 3x that in damages. So if you normally would license this photo for, say, $600, for example, and that you can prove that this would be a good analog to that license, then they would award $1,800. Just a good example of how it works. Bear in mind that things are going to go much better for you if you can prove actual damages. Cases in which no actual damages can be proven or the actual damages are very low, the CCB has been awarding the statutory minimum of $750. Now, once again, $750 is definitely more than, we'll say, the $300 to $400 that we talked about earlier as the actual cost of filing with the CCB. But you have to decide if that amount is worth it. This is still going to be a year-long process. You are going to have deadlines. You are going to have obligations you have to fulfill as part of this. So, yeah, just keep in mind that you are going to have those kinds of obligations, and it's going to be a part of your life for the next year, year and a half, or whatever. and there may not be a ton of money at the end of it, even by the CCB's comparison. So yeah, those are 3 things you definitely want to keep in mind. Overall, though, I do think the CCB is a great tool, and there have been a lot of cases that have showed the power of the CCB. Games Workshop, for example, filed a series of cases against someone who was making available 3D models of some of their miniatures. We have seen Paramount Pictures use the CCB to resolve a dispute over a pop-up restaurant. That one ended in a settlement, but the case took place in the CCB. So there are times and places where the CCB can definitely be incredibly useful, especially for helping encourage negotiation and reaching a settlement, and also collecting a more reasonable amount of damages for relatively minor cases of copyright infringement. Well, thank you very much, everyone, for watching this video to the very end. I hope you learned something, and that at the very least you found it entertaining and maybe a little bit useful. The CCB is an interesting institution. Please do check out the CCB at ccb.gov, ccb.gov, a very easy website to remember. I'm truly jealous. Maybe that's because my domain is plagiarismtoday.com. Yeah, that's a monster spell, I understand. But yes, definitely go there, check it out. I'll put a bunch of links in the description to articles I've written about the CCB, including one about the true cost of filing with the CCB and sort of some examinations of the determinations the CCB has been handing down over the past 18 months or so. Well worth checking out if you're interested in it. Also, check out my consulting site at copybyte.com, copybyte.com. Let me know if there's any way that I can help you out. Until next time, though, this is Jonathan Bailey, signing off.